Thank you so much, Tom. And last but certainly not least, we have Ryan Mulvey, Policy Counsel at Americans for Prosperity Foundation on FOIA case law developments in the Supreme Court and circuit courts.
Thanks, Ginger. Let me try to share my screen. Let's see if this works. Okay.
Perfect. Thank you.
Is that showing? Okay. Great. So I'll try to be quick. I'm glad there's still people in the audience. So I'd like to highlight some cases and some existing splits that I think are of particular interest to people in the transparency community, or decisions that just have great import. I can't get into detail with all of them, so I'll just try to highlight some key issues in each. Let's start with a recent Supreme Court decision from the beginning of the year in Sierra Club. The records at issue here were draft biological opinions, and the question was the scope of the deliberative process privilege. The Supreme Court, what I'd like to point out as particularly important in discussing whether a record should be protected as deliberative, suggested that courts should attend to whether or not legal consequences flow from the decision-making that the record reflects. This is sort of an importation of Bennett v. Speer, and if you take it at face value, it is a huge expansion of the deliberative process privilege, because there's lots of agency decision-making that doesn't result in legal consequences, and if that's going to be an essential part of the test, requesters are going to be deprived of a lot of information. So it'll be interesting to see how this precedent is taken down into the different jurisdictions over the next couple of months. There's a petition for cert pending right now from the Ninth Circuit in Rojas v. FAA. This deals with Exemption 5's threshold consideration of whether a record is an inter or intra-agency memorandum or letter. Many of the circuits, all of them, in fact, except the Sixth Circuit, have argued that the plain text of the exemption shouldn't be adopted, that we should adopt a functional approach, and outside consultants that assist an agency in its efforts, in its work, should be protected under Exemption 5. The en banc decision here in the Ninth Circuit reversed an earlier panel decision that rejected the consultant corollary. So we'll see if cert gets granted there. Relatedly, there's a Fifth Circuit case, Job versus National Transportation Safety Board, which doesn't deal so much with the consultant corollary. It reaffirmed it, but the particular question of whether records with a consultant should qualify as intra-agency because the outside consultant has an interest in the agency's deliberations. So here, the agency basically seconds representatives of aircraft manufacturers and operators. And in this particular case, the records reflected communications between the agency and such outsiders in a crash involving a helicopter that was designed by the manufacturer and operated by the operator. So there's obviously a conflict of public and private interests there. So we'll see if cert gets granted there. That should be an interesting question. Open FOIA Act from 2009. You may recall that Congress now requires that new Exemption 3 statutes cite to the FOIA in order to be qualifying exemption statutes. This case deals with the 2012 T-Hart rider, which prohibits expenditure of agency funds to release records about firearms tracing. The Ninth Circuit here said that the 2012 T-Hart rider, which doesn't cite to the FOIA, is not a qualifying Exemption 3 statute. Like that's the end of the analysis. This creates a circuit split now with the Second Circuit, which last year said, well, really the Open FOIA Act is an unconstitutional legislative encroachment. A present Congress can't bind a future one. So the 2012 T-Hart rider, even though it doesn't cite to the FOIA, is basically like an implied repeal of the Open FOIA Act. And we shouldn't take that requirement from FOIA too seriously. So we'll see where this circuit goes. I don't think the clock has run out on the ability of the government to appeal in the Ninth Circuit case. So we may see this coming before the Supreme Court relatively soon. As a side note, each of these cases about with the T-Hart rider involved arguments by the agency as a secondary matter that a search would result in the creation of a new record, that the disclosure of database electronically stored data would entail the creation of a new record. That typically is an agency has no obligation to create a record to respond to a request. But it's also established that the disclosure of existing information in an electronic format shouldn't be entail the creation of a new record, at least for purposes of determining whether the agency has an obligation to process a request. The DC Circuit addressed this year with GPS data. It said a requester could get longitude and latitude data, but the agency couldn't be forced to create maps. So there's all sorts of cases that are coming out about metadata and different types of database stored data. It's a live issue, unfortunately. Subject matter jurisdiction under the FOIA. This is an issue that has come up in a couple of cases, but earlier this summer in a case about access to internet browsing history records, the DC Circuit clarified that agency control, the question of whether a case implicates access to agency records, is a merits question and not a jurisdictional one. And this is great because it preserves the burden on an agency to have to justify its treatment of records. Otherwise, a requester would have to prove in the complaint, plead facts sufficient to prove that the requested materials are agency records, and that is a very difficult thing to do. Foreseeable harm. This is a great case, Reporters Committee versus FBI from July. Requesters have been for a long time trying to argue that the foreseeable harm standard imposes a heightened burden on agencies. They have to go beyond technical grounds for applying an exemption or a privilege. The DC Circuit has confirmed that. Reciting the justifications for the use of a privilege isn't enough. You have to give a concrete explanation for why particular records at issue are disclosable, given the context of their creation and the decision making. And we'll see further fights over this because district courts are always trying to pare back the import of the foreseeable harm standard. And as Freddie mentioned, this is an area where public interest balancing test or other reform would be an interesting idea. I'll skip this case. Remedial authority under 552A2. This is FOIA's proactive disclosure requirement, the reading room provision. The Second Circuit recently confirmed that a court can order an agency to comply with its reading room obligations and make records available to the general public. This builds on an existing split between the Ninth Circuit and the DC Circuit. The Second agrees with the Ninth. DC says, no, a court can only order if an agency hasn't posted proactively records it should have in its reading room. It can be required by the court to produce records to an individual requester, to the plaintiff, but it would go beyond the scope of the remedial authority of the court to benefit the general public by enforcing the reading room provision on its own terms. So I expect this to be a decision that comes to the court, and remedial authority of the courts under the FOIA is definitely an area where we need some reform. And then finally, this is an older case, Whitaker versus Department of Commerce, but, and I think Freddie mentioned this is a relevant decision because of the infrastructure bill that passed last week. Several years ago in 2012, Congress created the First Responder Network as part of the Department of Commerce, and it exempted First Responder Network from Chapter 5 of Title 5, the APA, but that includes the FOIA. And the Second Circuit confirmed that the plain language of that broad exemption applies. FOIA is part of the APA, and you're just out of luck. Well, the infrastructure bill last week, with respect to the new broadband equity grant program, that program is exempt. All commerce agency action relating to that program is exempt, not just from Chapter 5, but Chapter 7 of the APA. And this kind of snuck past, I think a lot of people, I don't think Congress even realized what they were doing. So this is a troubling development, and I think it shows why we should all be very attentive to these broad categorical exemptions to the APA for the sake of what the agency claims it needs as flexibility in administering the program, because there will now be absolutely no disclosure, transparency into the expenditure of government funds for this grant program. And that, I think, is particularly troubling. So I thank you for your time.
And yeah, agree that provision for broadband is very troubling. There's a lot of money that's going to go out of the door, and we're going to have